We're going to go live. In 5, you can go live.
Good evening, everyone. Welcome to the inaugural lecture in Live Law's Practitioner Series. Today, we have with us Mr. R. Basant, who is a senior advocate of the Supreme Court and a former judge of the Kerala High Court, who is going to speak to us on the fundamentals of criminal trial. I'm the moderator for today's session. My name is Gautam Shankar, and I practice as an advocate in the Supreme Court. Before we begin, and before I hand it over to Mr. Basant, just a few introductory remarks from my end. Firstly, I would like to congratulate Live Law in this initiative that they have taken. There is a crying need for continuing legal education across the country. And there is also a sort of absence of institutionalized mentorship for young lawyers across the country. So I think an initiative like this goes a long way towards meeting that sort of need. And I do hope that this is an initiative that not just starts today, but continues with full strength for many, many years to come. So I would wish them the best of luck in this regard, and hope to be part of many more such events by then. Now, let me come directly to introducing Mr. Basant, who is here with us today, who's kindly consented to give this inaugural lecture. For lawyers in the Supreme Court and for lawyers from Kerala, Mr. Basant needs no introduction. He is a very highly respected member of the Supreme Court Bar, who started his practice several years ago in the trial court, and then as a lawyer there, then became appointed as a district judge and then a high court judge, where he retired sometime in 2012. Thereafter, he's been practicing in the Supreme Court. Mr. Basant is a rare legal luminary who combines the rich experience of both the bar and the bench. As a criminal lawyer, he conducted many sessions trials. As a judge who presided over thousands of trials and later on as a high court judge, he can offer us valuable insights into the working of the judicial mind. Probably this ability of his to assess the judicial mind is enabling him also to excel as in his present role as a senior advocate in the Supreme Court. With his deep erudition, excellent advocacy skills, and a wide understanding of human nature, R. Basant can inspire and enrich young legal minds across the country. And I have no doubt that this lecture will be one of those inspirational moments. I have personally had the opportunity of seeing Mr. Basant very close in action when I worked on a case, the Jayalalitha case in Bangalore, where he was, the disproportionate assets case, where he was one of the lawyers for several of the accused. And I know how much he puts into his preparation, how meticulous he is. So I have no doubt that, we would all learn greatly from him during the course of this lecture. Before he begins, and before I hand it over to him, just a few housekeeping requirements. All of you who are attending, and you have questions, I would request you to put your questions down in the Q&A chat box that is available. And towards the end of the lecture, once Mr. Basant has finished his speech, I will collate those questions and I will I will ask him those questions. That's it from me for the moment. Let me hand over immediately to Mr. Basant. And thank you, sir, for being a part of this, and we look forward to it.
Thank you, Gautam. Good evening, all the listeners. The world is passing through very difficulties. The pandemic has thrown us all out of gear. The legal profession is no exception. We read a lot about the sufferings of the young lawyers all over the country. Their financial insecurity we come across, we read. We see the valiant battles which the bar councils and the bar associations are fighting to keep the young lawyers in good spirits and to keep the wolf away from the doors. We also see even a state bar council has permitted people to ditch the jealous mistress and then take up other assignments if necessary. Yesterday, I was shocked to see a clip which showed lawyer trying to sell tender coconuts to keep body and soul together. All these we're all passing through very difficult days, no doubt about it. The whole world is doing that, and therefore one has to wait patiently to get out of this. And I'm sure you will have the fortitude. The young members, I know the senior members may not have that much of a problem, but the young members must certainly be able to have the fortitude to keep things going. It is in this context that I see the live loss effort. Right through, I've been watching with great interest. A lot of webinars, a lot of training sessions are all going on all over the country. It shows to me that we are really a learned profession. The profession of law has acquired the sobriquet of being the learned profession. Even in these trying times, I find we are not letting loose, let the learning part of it to be forgotten, and that makes me very, very happy to see that. I would recall, I keep saying this in all these seminars and training sessions, judicial academies. Very interestingly, the Constitution of India did not have a chapter on fundamental duties. It came in 1977 during what they call the dark days of Indian democracy. I don't want to get involved in politics, but dark days of Indian constitutional and legal history, 1977. This chapter 4A of the Constitution came into the Constitution. It has only one article, 51A. It narrates the various duties that we have as citizens of India. It started by saying it shall be the duty of every Indian citizen, 51A. I don't have the time to tell you all the others, they're not relevant. What is relevant is only J, and the J says to strive for excellence. It shall be the duty of every Indian citizen to strive for excellence in all spheres of human activity, individual or collective, so that the nation rises to higher levels of endeavor and achievement. Poetic words. I think every professional must know this. How much strive for excellence is a part of our duty as a constitutional duty, as a citizen of India. More to be said about professionals. It is the indisputable duty of professionals to make sure that you strive for excellence. I always see, yes, as Gautam told you, I have a vertical experience from the smallest to small, the trial courts to now the Supreme Court of India. I know that mediocrity rules the roost in our system. It is very important that we imbibe the spirit, the constitutional duty of strive for excellence, yearning for excellence, and it is that constitutional duty which I find being translated into tangible action by the live law in taking up a project like this to discuss problems of contemporary importance, as also of direct help to the members of the bar. I also hear, I've been apprised that my audience today is going to be mostly from the trial court sector. I'm very happy to see that. When I started practice, the trial courts were strong, bastions of legal learning. The migration from the trial court to the high court was not as frequent or as common as it is now, and therefore we had towering lawyers at the grassroots levels who could be examples for the others. And then it is in that view that I say that the trial court lawyer has a very, very important role to play in the entire fabric of the judicial system. I do hope that the trial court lawyers will, by their learning, by their erudition, by their dedication, by their commitment, will be able to assert themselves. And therefore, I'm particularly happy that this happens. I do wish you the pandemic havoc will be over soon, and we'll all be back. The resurgent bar, which will come back to its limelight and professional excellence as quickly. Now, you're all, I'm told, when you are trial lawyers, I know whenever somebody comes, you don't hear him as a witness. If he comes, he asks you, what is your credential? 45, Section 45 of the Evidence Act, I don't want to hear you unless you explain your credentials to me. Why should I hear you? what is your competence? I must confess that Gautam has said very good things about me, but I think it was duty to exaggerate today. He did it eminently. It's my duty to be realistic. I would like to tell you just one thing. I have experience of half a century in the system. Well, that's my only credential. When I say half a century experience, I mean initial 3 years as a onlooker, law student, you saw life in the system. The next 15 years, I tried at the grassroots level, appearing before the magistrate, before the sessions court, and very, very occasionally before the high court, primarily before the trial court, and under a very eminent senior counsel, late Bhaskaran Nair, my senior, who was the doyen of the Calicut bar, to be trained. As Gautam rightly said, these are days when there is no mentor. There is no proper mentor for the beginner. Earlier when I started practice, they used to say at least 7 years with a senior, and then only you can be. Now young people will laugh at me if I say that now, but those were the days. The court craft, the court etiquette, the court behavior, the court pleasantries, the court's dignity, all these used to come down from your senior to the junior, and then like that it used to be passed on. Today, I find many a junior directly coming to the court and starting practice, just as many trial judges are directly from the law college and they start presiding over trials. These are problems which the system has. But then, it's very important that you are properly groomed, and therefore, I always acknowledge, with great gratitude, think of my senior late Bhaskaran Nair. Whenever I think of anything, if a person or we juniors have been able to achieve anything, it is because of the great personalities who mentored us, and that is very important. That's about 6 years I was with him, and the next 9 years, altogether 15 years as a trial lawyer at the very grassroots level I had experience. And then another 15 years I had experience as a session judge. As a session judge, you do trial work, you do appellate work. You must enjoy that part because every day morning when the court opens, you have every type of case, civil, criminal, all types of cases, appellate, original, all types of cases, and that is an experience that stands you in very good stead in your future life. Therefore, I had that experience for about 15 years as a trial judge, session judge, and that period I could preside over various districts and look after the administration of justice at the grassroots level and understand where the shoe pinches. That is a very great experience that I had. 15 years as a lawyer, 15 years as a session judge, and the next 1 decade I had experience as a judge of the High Court. And after 1 decade when I retired, I thought I shall be enjoyably occupied and be there in the Supreme Court rather than take up any other assignments, and that's how I landed myself fortunately in the Supreme Court to see the system working at highest point. This is all that I can tell you. I have interaction with the system at various levels for a fairly long period of time. And what I'm now today trying to discuss with you is, I don't want it to be a mere training session as such. I would like you to look at things from a higher angle and find out what are the fundamentals of the legal, the trial system, how it works, how it helps us, how it does not help us, how we should think of improving it. What are the stakeholders? What is your role as an advocate? These are things which I would like to discuss. Now, when I go to the first part, I remember when we joined the bar, things were much rosier than this, and there was idealism very much everywhere in the air that we breathed. Now, in 1947, when India became independent, we were at the end of a great battle in the sense it was unknown to the world till then. The world did not know that imperial power can be thrown out and we can be liberated through the sublime weapon of nonviolence. That was history for the world, that many countries were inspired by it, and then we went on. We created history. When the Union Jack came down, it was the end of an imperial rule and people getting political liberty from the freedom from the imperial masters. Well, that was at the same time the beginning of another war, another independence movement, another justice movement. We promised to ourselves the justice, political, social, political, and economic through the rule of law. Well, that's very important to me. I think that is where I want every lawyer at every level to understand that it is our good fortune to be part of the system. Well, think of those times in 1947, 50, when they were planning about the type of governance that we must have. They thought of all the options. They had all the options before them. Now, India was a country of a feudal country, a very conservative country, a very superstitious people. Under every possible line, look at the literacy line, look at the poverty line, look at the industrialization line. Every line we were much far below the line. What was the option for them? Because we had very yellow options from the north. You could trample upon individual rights. It's a rich country of poor people, and therefore you could capture the wealth and distribute it among people equally. The founding fathers of this country, inspired by the noble traditions, decided, no, we'll not do that. What shall we do? We decided that we will distribute rights equally. The wealth equally, but the wealth of rights will be distributed equally. And therefore, when the Indian citizen gave unto himself the constitution and woke up the next day, he found a lot of rights in his pocket. Well, little did you know what to do with the rights, but he did have those rights. He had those rights, and he had to exercise those rights. Equal rights for all was guaranteed under the constitution and distributed on the first day. Everyone had equal rights. What is he to do with that? How does he do it? How does he exercise that? And that is where the legal profession became very, very important. In order to make this conferment of equal rights real, effective, meaningful, in order to fight a new battle, which people didn't ever know what it was, and undernourished people trying to work out justice, attain justice through the instrumentality of law, change in accordance with law. Justice by rule of law was a concept which placed very heavy burden on the shoulders of the lawyer community. The legal system, particularly the legal system, was burdened with this heavy responsibility of this unique fight, which unprecedented fight for justice through law, which we introduced in this country. I want every lawyer to understand, every functionary of the judicial system to understand that this was the great tradition, which was the great fortune that we had as a law community, that we had to fight this war and prove to the world that it is possible for a feudal, undernourished country to become a part of a knowledge society, of a justice society, by distributing rights equally. There lies the importance of you and me as functionaries of this legal system. Therefore, I think it's important that young lawyers understand, at the bar of history, if we do not succeed, we'll be held responsible, we'll be held guilty. We had a great opportunity to prove that you can do it, which would be a lesson for future various countries, but if we squander that opportunity, we'll be found fault, we'll be found guilty at the bar of history. And therefore, the lawyer every lawyer should learn, know, understand that there is a very heavy burden on him to translate the constitutional promises, equal rights, into meaningful realities for the polity. Having said that, I think I must now take you to the they say criminal lawyer, isn't it? A very bad expression, a criminal law practitioner in future also, in the course of the discussion, if ever I stray on to commit the mistake of saying criminal lawyer, it only means lawyer practicing on the criminals. You generally say criminal lawyer. It's not a very, very good question. I wouldn't like to be called a criminal lawyer, so it's a little difficult for me to digest that. But a practitioner on the criminal side, he has very great responsibility. You understand, for him it's very, very difficult. I know every idealist young man who faces life in the second decade of its existence. I mean, all of you become lawyers by 2022, 23. You has a lot of idealism in you. I'm sure only capable persons come out and join the bar. It's my conviction, only confident people come out and join the bar. And then when you join the bar, you have this responsibility. What am I going to do? Am I the mouthpiece of a criminal? Am I the mercenary fighter for a criminal? Well, many other professions, you find this conflict is not there. You become a teacher, you're an honest teacher, you're no problem at all. You're an honest doctor, you're no problem at all. You're a good judge, there's no problem at all. But so far as the lawyer is concerned, there is a conflict of crisis of conscience going on within you, especially of the criminal variety. Those practitioners on the criminal side, they often, I had this problem, and therefore I can visualize that many a young man listening to this from the grassroots level must be having this problem very much before it. What am I supposed to do? As a young lawyer, I used to think, you promise me the whole gold Stockton fortnots, I may not say something incorrect. That is, as my conviction about myself, I would not do that. I wouldn't want to do that at all. But the professional duty that I have, I look at facts in such a way that I try to generate various probabilities. Preponderance of probabilities is what I'm trying to take the judge to. And then I take him through all that to say, see, sometimes the trial, the High Court to the Supreme Court level, there's no problem. You don't interact with the client mostly. You are only briefed, and then you don't know. But then at the trial, at the grassroots level, the lawyers must be facing this problem. Sometimes they think that they know the client is guilty. Who am I fighting for? See that am I lending my faculties for a throwaway prize to a person who is guilty on his own showing, or who does not measure up to high standards of behavior which you would impose on yourself? And therefore, the trial lawyer has this great conflict. In addition to the conflict between correct and incorrect, you understand what I mean. A person as a case, he is thinking whether it will be correct in the situation to take up a plea of total denial or to take up a plea of one of the special defenses. This is a conflict of correctness and incorrectness. But for a lawyer, there is an additional conflict of right and wrong, which is not there for many other professions. Honest professions, you will not have this problem. But a lawyer practicing on the criminal side often comes across this question, and then wants to. It's worrying him. It's a crisis of conscience. It's worrying him. It is important that we have the right state of mind to conduct a criminal case. You ought to know that. It's a mind that matters in a situation like this, and therefore I want the trial lawyers to be never apologetic. There's no reason to be apologetic at all. You are not a mercenary for a criminal. You are not a fighter for crimes. You are not the beneficiary by crimes. What you're trying to do is the civilizational finesse, the institutional safeguards of ensuring that justice is administered. A lawyer practicing on the criminal side is actually a defender of freedom and liberty. Let it be very clear. I don't want anyone to have any doubt about. I find some of us become defensive. It's important that you understand that this is not the occasion to be defensive or apologetic. Every profession has its own dharma. And the dharma of a lawyer practicing on the criminal side is to try to take the judge to that point, that vantage point from where, if you view things, the matter will appear to be more on your side. Truth is never unidimensional. It is multidimensional. You have to position yourself in such a manner to find out what is and from which point you can look at truth and see some advantage for your client. You must always remember, you must always know that burden is on the prosecution in our system to establish. And the accused has a right to insist and say that these are inadmissible evidence, these are not sufficient, they do not measure up to the requirement of proof beyond doubt. This is all what he has to say, and it is an institutional, it is the civilizational finesse to point it out to the judge and tell the judge that this is, oh, be very sure of that. No, I want trial lawyers at the grassroots level, particularly all practitioners on the criminal side, to be very sure that you are not a mercenary for the crime or the criminal. You are a warrior for institutional finesse, civilizational finesse. See, that is what is important. I just thought that I will not take you through any decisions or anything, but two observations from the American courts which came, I thought was very, very important for us to realize what is the real role of a criminal practitioner on the criminal side of law. This is Justice Frankfurter said, it's a fair summary of history to say that the safeguards of liberty have frequently been forged in controversies involving not very nice people. You are battling, you are fighting for freedom and liberty, and in this, it may not always be possible. Maybe that you're not involved with very nice people. They may not be very nice people, but still your fight is for freedom, liberty, and the constitutional values. The Court of Appeal in another case said, this is more interesting. It said, one who would defend the constitutional rights, they said that defend the Fourth Amendment, must share his foxhole with scoundrels of every sort. Look at those lines. With scoundrels of every sort, but to abandon the post because of the poor company is to sell freedom cheaply. Well, every lawyer practicing on the criminal side must shed the attitude of apology, attitude of diffidence, and say, I am not a mercenary for a criminal. I am fighting a war for freedom, liberty, the civilizational refinement. This is the attitude which you ought to have. And I would like you to always remember that it is this attitude which alone can give you satisfaction professionally. If you reduce yourself and deteriorate into just a fighter for a criminal and to save him somehow, I'm afraid you're losing the sublimity or the assignment that you have. And therefore, I would think that every lawyer practicing on the criminal side must be very sure that I'm not, maybe in this particular case, I'm appearing for a criminal. I'm trying to justify him as much as possible and point out that the evidence falls short of the required rate. The freedom and liberty cannot be taken away on this sort of materials available. Yes, I'm doing that. But no, it's very interesting, because the latest perception of the lawyer is the one who lives on crimes, right? Many a member of the laity would think a lawyer practicing on the criminal side lives on crimes. That's one. Not only the laity. I want you to see how lawyers react. Some of the lawyers say, if I appear, I will not appear for cases against the lawyers. Their cases are, the accused has committed a crime against lawyers, I will not appear. This bar will not allow any lawyer to appear. These things are very common these days, and therefore it's important that you understand that. Now, some of them say, no, rape offenses, I will not appear. Well, if you have a personal difficulty, don't appear. I'm not on that at all. If you feel convinced that you can't give the best to your client, you don't appear. That's not the point or problem at all. The problem arises when you think that some crimes I will not appear. It's a little difficult because you are not on the principles rightly. Because are you appearing in other cases because the accused is innocent? To say that I will not appear in certain classes of cases alone? Well, in every case that comes to you, you are trying to find out whether there's any justification from his point of view, either to claim exoneration or at least to claim extenuation. That is what you're trying to do. You are trying to show to the court that the rigid standards of proof beyond doubt which ought to be there in a criminal case is not answered. And therefore, the right state of mind, I also wanted to tell you, sometimes, it's interesting, in the Supreme Court, when I appear for there are some very harsh cases. The harsher, the more difficult the case, they would want to come to a senior counsel. Usually that happens. I appeared in one case, the bench told me, "Oh, Mr. Basant, a senior counsel like you should not appear in a case like this." Well, it's interesting, I believe it's perhaps a want of appreciation of the type of battle that you and I are fighting for the criminals. In the light of such gross want of understanding of the role of a lawyer practicing on the criminal side, it's important that he assures himself what he is, and that is why I would always think, be very satisfied that you are not a mercenary. I keep repeating this expression. You are not a mercenary for a criminal. You are a sublime warrior for the constitutional finesse of liberty, freedom, and institutional safeguards. Well, once that is so much is very clear about you in your mind for what your role is. Well, what is the role of the system? We are all members of a system. What is a system and what is a member? I need not tell you. System is something that accomplishes a task. Members are parts of the system, right? This is the member and the system. Now you have the digestive system from the mouth to the anus, and then each has a role to play in the system. The macro system has a role, and the micro functionary has another role. In the broad way, a role to play. What is the role of the criminal justice system, and what is the role of the lawyer therein? Important that we look at these fundamental questions and understand, so that we become better lawyers as we. I've always asked this question in academies. What is the purpose of the criminal justice system? The criminal justice system, I get answers to punish the guilty, to exonerate the innocent, and all this, that. But what exactly is the purpose of a system? Those students of political history will tell you the state is an entity created by the polity. I give a lot of my rights to the state. I surrendered my rights to the state. I agree to abide by the law of the state. I pay taxes to the state. All for what? There are two inevitable things that the state should assure me. One is protect me against external aggression. Two is protect me against internal disturbances. I would call this internal disturbances. In the larger sense, I would call them a crime. They are crimes. When I go out of my house, when my grandchildren go out of the house, I want them to come back in one piece, without being afflicted by crime, without the threat or the fear of crime. So freedom from crime is a very important, which every modern state, every state, from the original constitution of the state, this was the duty of the state. Now, you will also know that in a constitutional democracy like ours, Article 21 says the state should protect your right to life. My right to life, it's also an incident of my right to life that I must have freedom from crime, freedom from the threat of crime. So both the traditional state as well as the modern state has got the duty to protect a person from crimes, save him from crimes. And that's why I would always say the purpose of the macro system is, it may sound a little utopian, a little idealistic. The purpose of a modern state is to endeavor to achieve a crime-free state. A crime-free state is a guarantee which the state will have to give to its citizens. Now, how do you achieve that? And that is where the system comes into play. You have to ensure that criminals do not commit a crime. It's not the punishment of the guilty, is not the purpose of the law. Exoneration of the innocent is not the purpose of the law. purpose of the law, criminal justice system is to ensure that people are free. They have freedom from crime and the threat of crime, right? This is the broad system under which you work as legal practitioners on the criminal side. This is the macro system must try to ensure that a crime-free state. All the others are incidental. You prosecute an offender, you find him guilty, punish him, you exonerate some. All are incidental. The main purpose, of course, is to ensure that we have a crime-free state. It is utopian. I told you, those who have studied calculus will say it can only 10 to 0, it will never become 0. Crime will never become 0. It's always only 10 to 0. That is the purpose that we have got to achieve. Do we achieve this? If but deterrence is the best answer for people think the criminals and like-minded persons should not be tempted to commit crimes, and therefore we have the burden to ensure that they do not commit crimes, for which we have to respond. Society has to respond to crime. In a society wedded to rule of law, there is an inevitable distance between crime and its punishment, or may I say crime and the response of the state to the crime. There's an inevitable distance. Or the ultimatum comes. A little later, I'll take you through the fundamentals of a criminal trial. All those will have to be observed, and which means inevitably there's a distance between crime and its consequence. That's a punishment. Now, the lesser it is, the better for us. The lesser this is, the better for us. I've always felt that the true deterrence lies in the immediateness of the response of the state, which must tell you there's a great need of expeditious criminal justice. You cannot postpone the response of the state to an uncertain future date. And therefore, the system, in order to achieve a crime-free state, you will have to immediately, the response immediate. And immediate, when I say, there is always a distance. I don't think that you have a crime committed, from there to the police station, from there to the gallows is not what I talking about. The refined systems of law, there must inevitably be a distance between crime and the response of the polity or the state to the crime. And therefore, expeditious justice is one of the sure deterrents against crime. Next is certainty. Punishment must be certain. The offender must know that he will be caught. There's no escape. Now, the better the lawyer you engage, you will escape. The costlier the lawyer you engage, you will escape. That should not be the attitude. The system must convey eloquently, unmistakably, that the criminal will be caught. So I would think certainty of punishment and expeditious response are the two matters that will ensure a crime-free state for that. We are part of the system. It is our duty to ensure that these things happen. And therefore, it's important that we understand that for the macro system to be effective, to serve its purpose, we have got to ensure that the micro functionaries function in such a manner that we march towards a crime-free state by immediate response and certain response. We commit a lot of mistakes. As a country, as a people, we commit a lot of mistakes. As soon as the grave crime like the Nirbhaya crime takes place, as soon as another crime takes place, there's a hue and cry. And then they say, till now, rape will be punishable with life sentence. Hereafter, it will be punishable with death. Little realizing that it's a knee-jerk reaction. Severity of punishment does not serve as a sufficient deterrence, as does certainty and immediateness of the punishment. My point is only this. The functionaries at all levels must realize that it is the duty of the system to respond adequately, expeditiously, with certainty to a crime that is committed in order to achieve the purpose. Well, once we are sure of that, a question arises that we have been dealing with this system for the last 73 years after independence. We have been dealing with a certain system which we call the Anglo-Saxon or Anglo-Indian adversarial system of criminal trial. How effective has it been? A sure yardstick or a sure touchstone on which you can verify is the satisfaction of the people. What is the message that goes around today? Well, I believe no one, I don't know whether any one of you is satisfied with the functioning of the criminal justice system. I'm not. I'm not satisfied the way the criminal justice system functions. And it is full of uncertainties. It is full of long delays, so that your ideal of a crime-free state cannot be achieved by the way the system now functions. That's all that I would say. The message that the system must be sending around us: crime shall not pay. The response will come certainly and immediately and will catch you up. But that is not the message that we are now sending around at all. Look at the percentage of convictions. Look at the distance between crime and punishment. In any view of the matter, you find the message that goes around is that this system is not delivering the goods. Oh, that is why I would think that sometimes people take law into their own hands. The law enforcement machinery themselves take law into their own hands. The Telangana rape killings, if I may call it, is a classic example of how people are appreciating that the law enforcers are taking law into their own hands. After 17 years of rule of law, if the chief minister, the politician, the polity, everyone would start congratulating and offering sweets to the persons who committed the murder, I'm afraid that it is an electoral declaration of the failure of the criminal justice system. People are not satisfied. Let's not lull ourselves into complacency, thinking that the system is working today and therefore people are satisfied. People are not satisfied. I'm convinced that people are not satisfied with the way the system works. Last week, you must have read, the Supreme Court asked all the high courts to tell them at the old criminal appeals which are pending for more than 10 years. Just look at it. After 10 years of custody, this is not able to. Am I audible? Is there any problem? Am I audible?
Sir, you're audible.
Very
Please,
good. Sorry.
go
There's some problem. She went out on this, so I thought that not audible. Well, why does the system not work? Why is there perceived failure of the system? Well, I'm convinced that the system has failed. Now, if you think it has not failed, I'll give you the benefit of the doubt and say perceived failure of the system. How does it happen? I think it's very important that we do introspect. The system is to introspect. The functionaries in the system have got to introspect. We have got a commitment to the larger values, larger requirements of the system, and therefore the lawyer and the judge cannot be complacent, cannot think that he is not. What is our system? We follow the Anglo-Saxon system of adversarial trial. That is what matters. Now you find people start blaming the investigating machinery. People start blaming the prosecuting machinery. People start blaming the adjudicatory machinery. We blame all that, and then ultimately it's important that we find that the system is not good. Now the great debate that is going on now is whether we must switch over to the inquisitorial system from the adversarial system which we today have. This is a problem that we are debating and discussing now. Well, I think it's important that we realize what are the fundamentals of our system. Now, how are these fundamentals adequate or inadequate for our system? If with all this we are not being able to deliver the goods, what do we do? Are these fundamentals, which we think are fundamentals, negotiable? Can they be customized to meet the requirements of our system? Well, these are the thoughts which must go on, and I hear that there is some discussion, some debate going on at higher levels as to how the system can be changed, how the system can be altered. Before I come to that part of it, I'll say, the fundamentals of our legal system perhaps is in order to continue with the adversarial system, we have to fine-tune the system, and the system's requirements are, one is a fair and efficient investigation. Well, you will know, you will certainly understand that this is an utopian concept. The Indian police have so much discredited themselves that no one trusts the police. Would you know? I think you speak to outsiders other than those in the system, they will be shocked to hear that the Indian police does not have the right to record a signed statement of a witness. Forget about the accused. They do not have the power to record a signed statement of a witness. Well, we continue with the relic of the imperial British police, and we don't want to trust our police. I am convinced, I told you I have 51 years of experience, 50 years of experience in the system. I know the police and the way they are is not trustable, at least in the major parts of the country. Well, I find some exceptions coming up down in here in some of the states where things are improving. The technology is taking over. There is technology-induced morality among the police force also, and therefore things appear to be slightly marginally improving. But then we have not trusted the police at all. We distrust our police. The system, police is a part of the justice system. It's a case where one part of the system, one organ, one part of the system distrusts the other. We can't go much forward with this. I'm not saying that the today's police can be trusted, but certainly 73 years of independence, and we must be able to develop a democratic police force which has credibility. The first requirement, the inevitable fundamental of our system of justice administration today is a police force, a fair investigation, which remains only on paper. Police do not have the powers. You know that. You trust a person, you get back responsibility. You distrust him, you get back irresponsibility. This is what will happen. It's a human nature. Policeman knows that he can write whatever he wants. Nobody is going to trust him, and therefore he has no responsibility at all. Well, the Britisher, though they also started with similar law, today trusts Bobby. The American trusts his cop. We don't trust him. I repeat, I agree, because practitioners would think that does not this man know about the condition of our police, that is advocating acceptance of the police. I'm not doing that. But I'm only saying that you cannot delay it further. We have got to develop a police force which is credible, which is trustworthy, which can be required to meet the requirements of the justice system. And therefore, I don't have the time to go through. It's easy to introduce safeguards by which police can be given a little more powers and a little more. An absolutely not uniformed police force for crime investigation must be set up, and they will have none of the trappings of the uniform police force that we have. The police officers of and above a particular rank level must be permitted to record statements and take signatures. So those statements must be sent to the court within 24 hours. A copy thereof must be sent to the person concerned. And then it is for him to say, this is not what I said, this is what I said. Well, it's not impossible. Today's world, today's technological development, these are not impossible. We're not thinking about that. So the first requirement of fair investigation is more honored in its absence than in existence. We are not worried about that. We continue with a system of distrust to the police. You trust the excise official, you trust the customs official. Why? A police officer sent on deputation to the railway protection force, he can record the statement of a witness. Tata man can record a statement. He could record a statement. They've been abused considerably. I'm not on that. But the point is, we must be able to develop a trustworthy police force, and it must be the democratic, people-friendly police force of India. That is what we'll have to develop. We can't continue with this regular diet of distrust of the police. That's the first point that I wanted to make, when you speak of the fundamentals of criminal trial. Well, next is I'll have to rush through now. Next is the presumption of innocence. Presumption of innocence is is one of the shall I say inalienable human rights as they call it. I don't know how far it must be. It will be possible in a country like India. Absolute presumption of innocence, innocence with no obligation for the indictee to respond, and the right to silence, which we have trotted as a very important right for the accused, which is today deteriorating into an arrogant refusal to cooperate with the truth discovery process. Well, should we give an accused the right to silence, which deteriorates to such an extent that he does not cooperate with the trial, does not cooperate with the truth discovery process? I can understand, don't accept a statement made to him by the police till a credible police force is. But can he not be asked questions and answers in court? Like the 313 questioning that we have today, can we not understand what his defense is? Which rule of natural justice is violated when you ask a person to explain a certain fact? Well, I have my reservations. The over adherence to the right to silence makes the accused a villain of the peace. He does not have to open. He may plead, not plead, or refuse to plead. Still, the burden rests entirely on the prosecution. Well, it's time. I don't think the system can afford these luxuries for a lot more of time. Maybe we'll have to have a realistic methods of a criminal trial where some of these fundamentals may have to be compromised or at least customized or at least indigenized, as I will call it. Indianized is a very bad word in the Indian politics, and therefore I don't want to use the expression Indianized. I'll call it indigenized. We will have to regulate our truth discovery process. What is a trial? Trial is a truth discovery process. So there's an allegation, you are trying to find out whether the allegations are true or not. So today, even though the trial is an ascertainment as to whether the charge is true or not, it still remains a truth discovery process. Justice Chinnapuredi long back has said it's a voyage, the destination of which is the shores of truth and justice. And therefore, can we continue with this sort of a presumption of innocence? Because it is changing, you ought to understand that also. How many of you have seen the section 29 of the POCSO Act? Well, it's very interesting. All your notions about the presumption of innocence would fall if you read that section. It says, if a person is prosecuted for committing so-and-so offenses or attempting or abetting the committing of those crimes, it shall be presumed until the contrary is proved that he is guilty of the offense punishable. Of course, the Kerala High Court and some other High Court, the Justice Bhachi, the Calcutta High Court have dealt with this situation in some detail. But then go by the section, it says, if you are prosecuted, the presumption of innocence vanishes and is a presumption that you are guilty until otherwise proved. Well, the winds of change are coming. The dissatisfaction or the polity is getting expressed in the form of statutory provisions which shifts the burden. Now, in a 29, it was shocking to me. I am surprised that it continues to remain on the statute book. All the decisions that I read tell me that the constitutionality has not been challenged. I wonder when, what date the challenge will come. It has been on the statute book for quite a long period. Earlier, we deliberate on that better. But I want you to see the writing on the wall. Dissatisfied people we are no more going to be willing to concede romantic rights for the accused alone. And therefore, it becomes very important that the fundamentals of a criminal trial, as you and I have so far understood in an adversarial system, are customized, indigenized, altered, molded to meet the requirements. Well, proof beyond reasonable doubt is another. We need a lot of time to discuss that. Proof beyond reasonable doubt is nothing but proof. Section 3 of the Evidence Act defines proof, and then it introduces the concept of a prudent person standards. If a prudent person would insist on higher degree of evidence because of the consequence of deprivation of life and liberty, that is the only difference. That slight higher standard, we have been led to believe that there is magic in this proof beyond reasonable doubt. Proof is defined in Section 3. The section applies both for the civil case and the criminal case. Now, the higher degree of proof in a criminal case inheres in the definition. There is moving space elasticity within the definition. But we have been led to think that it's a magic, it's a mystery. There is mysticism in the concept of proof beyond reasonable doubt. Well, I believe that these are the things which bring discredit to the system as and not an effective method of crime adjudication, not an effective method of criminal justice administration. Well, I would just now see the 45 minutes to 1 hour that I wanted is almost expiring. I'll just put one more thing, These are times when we should think about how effective our criminal justice system is. How fundamental are the fundamentals which we have assumed to be fundamentals? How much of customizing, how much of indigenizing can come in to our criminal justice system in order to ensure a crime-free state, in order to ensure that a criminal would meet his requirement under law expeditiously and certainly. Well, this is what we have to find out. This is what we must try to find out. The system today is so unsatisfactory in its functioning. I'm including the unjustified prosecution. If the conviction rate is only 50 or around that today, what does it mean? 50% of the persons prosecuted are unjustifiably prosecuted. One possibility. Other possibilities, 50% are acquitted without merit. One of the two it must be. It's so evident. Today, I find that the conviction rates are slightly going up, but even then, I think it's nowhere near the ideal state of achieving a crime-free state, which we have to. Well, a little more, slightly higher thought. What is the law? What is the law? I believe the best answer, what is the law? What is justice? Well, justice is to each what he deserves. My simple definition of justice would be to each what he deserves. The ability of the system to give to each what he deserves is justice. You have committed a crime, punishment is the response, is what you deserve. You have been unjustifiably offended, compensation or say reparation is what is your due. So to each what he deserves is in one word, justice according to me. Now, what is the law? The law is the vehicle through which justice is rendered. The law has to be the quintessence or the common sense of the community. Beautiful definition of law would be, law must be the quintessence or the common sense of the community. If the community's common sense and the law's common sense are so vastly different, that law fails. That law does not operate. That law gets discredited. Every law, in order to be effective, in order to be a law by definition, if it is the quintessence of the common sense of the community, it must have the fragrance of Mother Earth. Law, in order to be law satisfying the definition of quintessence of the common sense of the, I take a caveat. Quintessence of the common sense of the community is not lay common sense. It must be a trained common sense. It's not a lay common sense. Given that, I'm telling you, the fragrance of Mother Earth must be there. No, I've been in the system for 50 long years. Now, would you believe, I don't know, the lawyers among you would easily find it. It'll find it very difficult to explain to. A comes and complains to me that B has beaten him. Very simple example. A comes to the court, to the police and says B has beaten him. What do you do? What do you do? You ask A or the prosecution to prove that B has beaten him. Do you ask B, what have you done, Mr. B? We don't. Really, we don't. That's the drama that is going on in our criminal courts today. We never ask B, what have you got to say? The poor prosecutor frets and fumes to prove the offense beyond reasonable doubt. The accused takes up a defense. Oh, I was not there at all. Then the prosecutor frets and fumes and proves that he is there. Tries to prove he is there. And then he says, if I were there, I had not attacked him at all. Well, and the prosecutor then has to prove that he had actually attacked him. That is proved at the stage of argument. He'll say, oh, if I were there and I had beaten him, I am protected by the right of private defense. Well, if all the three would fail, you would still say the allegation is not in the way you have alleged. What is established by evidence is not in the way you have alleged. And therefore, the chasm between the allegation and the proof, I'm entitled to take advantage of. Well, if you would tell an ordinary man that this is what is going on in court, he would rather try to forget the court. That is why I say the fragrance of earth is not there in our criminal justice system. A lot of discussion going on as to adversarial or inquisitorial. Ladies and gentlemen, I would ask you, why not a Deshi system of criminal jurisprudence? Is it so impossible? Can we not borrow from all the systems of the world and develop it with our own system, our own native common sense, and have a system which will answer, which will meet our requirement of a crime-free state, or a march towards a crime-free state? Is it so impossible to do that? Well, 73 years of existence, what have we done to improve our criminal justice system? Well, when the Nirbhaya case came, and tinkering here, tinkering there. In 1973, I joined the bar in 1973. When the 1973 code came, the Krishnayar was great expectations were there. Please look at the changes that have been brought about. Cosmetic changes here and there. I'll say cosmetic tinkerings here and there. Has there been a structural alteration of the trial process? No. There has been no structural alteration. So that the prosecutor does not know where he is going to be hit. Typical case. Take an example of an accident case. You were driving the car on so-and-so date, and you drove the car negligently. He has no intention of taking up a defense that he was not driving the car. After the end of the trial, you realize there is no evidence to show that he was driving the car. Look at it. See, are we just playing a complicated game where rules are more important than the end result? It's time we think. See, you must be disturbed. We must all be disturbed at the state of criminal law in this country. And then only the changes will come about. Then only modification will come about. This is what I feel. We are totally averse. We are totally averse to change except cosmetic alteration here and there. Now, I don't have the time to explain entirely, but then I would think what harm happens if the investigator is permitted to record statements. You have all sorts of technological safeguards today, and then it's recorded. And before the examination of witnesses start, on the basis of those statements, can you not question the accused to find out what is the difference? Should undisputed facts be proved and the accused be permitted to take advantage of that? I'm being a little unconventional. I'm conscious of that. 50 years of experience has not tempered me down. The first day when I went as a law student to the law college, I had all these doubts. 50 years down the line, I'm entertaining the same doubts. I don't find answers. I don't find, unfortunately, the search for answers. That is what worries me. A system of justice, criminal justice administration, which is not alien to this country. Anglo-Saxon jurisprudence, the Star Chamber experience, they are even today driving them from the grave. They have improved a lot, but we continue to remain where we are. Well, it is therefore, according to me, very important that we think of suitable alterations to indigenize the Indian law, to customize the Indian criminal justice system, to borrow from anywhere, even our constitution is that we are borrowed from every system possible, and then find out the system which will improve the justice administration, which will quicken the pace of our march towards a crime-free society, which Article 21, according to me, promises you. Well, my grievance is, none of us appear to be worried about. Nirbhaya case, a tinkering here, tinkering there, add the section, minus the section, done. That's it. Where is this? Where is the endeavor to structurally alter the system of finding out truth in a criminal, in order to make our criminal justice system effective? My final take is this: lawyers and judges may not do it at all. Well, it's Churchill who said, war is too serious a business to be left to the generals. An efficacious justice delivery system cannot be left to the lawyer and the judge alone. They may help the others, but it cannot be left entirely to them at all. That's what I feel. That the civil society must have a more better say in the formulation of law, in the alteration of law, and then only it would become effective. Well, change has not been our cup of tea at all. Right? Lawyers and judges are not great protagonists of change. We always follow what? We follow the principle of stare decisis. Stand where you are. We don't progress much. We are always overburdened with the burdens of the past, and therefore we don't alter significantly. We make it the 73 code is an outstanding example of that. 73 code, when it came, the earlier code, small change here, a small change there. But to meet the requirements of a society like ours, where the judicial time is precious, all unnecessary disputes should not go to the justice system at all. Well, I just, there's a lot to say, but I don't think we'll have time in a matter like this. Many of the offenses are punishable with fine only, or alternatively with fine. Some substantive section, alternative section. Now, should the trial process be gone through in all these offenses? We were discussing with the Director General of Police the other day, and he says the lockdown fines every day across the state of Kerala, 9,000, 8,000 cases are being registered for not wearing the mask. Are all these cases to come to the court? Where do we have the time for this? See, today a case requires 5 minutes for its disposal. I'm not able to give you those 5 minutes today. I'll give you that 5 minutes 5 years hereafter. Where is justice? Well, I think I like to conclude now. I have been, nothing succeeds like excess to make you think. I've sometimes swerved to the one extreme. I'm conscious of that. I'm very conscious of that. I've swerved to one extreme. But these are only to provoke thoughts, not that these can be accepted straight away. But my grievance is we are not thinking. We are not considering the structural alteration which must inevitably be there in the system. And that is what hurts me. 73 years of independence, we have not moved a wee bit in the criminal trials. We waste our time, we overburden our courts. Why not? See, some of the offenses can be dealt with, minor offenses which can be dealt with by imposition of a penalty, as in the case of a customs offense or a central excise offense, and the non-payment, the amount alone need be made a punishable offense. It's possible. It's possible for us to remove a lot of unnecessary weight from the shoulders of our justice system, so that unnecessary trials can be avoided. Even in necessary trials, a lot of unnecessary work can be avoided. Thank you very much. No, I thought the time is up, and then I have only tried to project to you what we think are fundamentals, which fundamentals require readjustment, which we are not doing, and therefore I think we must. Every functionary in the system must think first. From the thinking comes the change. No change ever comes before the thinking takes place. Even the grassroots level lawyers, the appellate lawyers, the lawyers at the highest level will have to think. I have in many academies, I said, why don't you, instead of speaking about the inadequacies, have a committee constituted to formulate a model code of criminal procedure for India? Well, I am now given to understand. I've read a letter from the Home Minister to the. I'm not saying that is the answer, but the fact that some thinking has taken place for a Deshi jurisprudence, if I may call it so, in contradistinction to entirely borrowed systems, will definitely help us to go a long way to the final result of a crime-free state, or a state where crime is eliminated to the maximum extent, where people live without being afflicted by crime and without the fear of crime. Thank you very much. That's all. That's all.
Thank you so much, sir, for your extremely enlightening lecture. My key takeaways from it were that I really like how you position the trial lawyer not as a mercenary for crime or the criminal, but as a defender of freedom and liberty. And how you situated that in the context of how we suddenly became rights bearers as citizens of a newly independent country. I think that to me resonated very well. I was also very happy that you pointed out the importance of the right state of mind that a criminal trial lawyer should have. Because I think one of the ongoing discussions that we are having in the profession today is the importance of mental health and how we approach questions of mental frames of mind while doing our work as lawyers. And so again, thank you so much for taking us through the what are these key tenets in the larger framework of the criminal system. I think what does the criminal system, justice system achieve or hope to achieve, and what is our role as a lawyer in that larger systemic sort of objective. Now, I think the point that you make about very fundamental changes being structural changes being required is very important, and I think there is definitely we are moving around to this view that the adversarial system is not really working for us in the way it should be, and we need to rethink basics to sort of indigenize it, as you rightly said. Now, I do have some questions of my own, and I'm flooded with questions from the audience. So that is clearly very good signs that we've engaged them very well with your lecture. And so, in fact, there are so many questions here that I cannot possibly ask you all of them. So I'm going to sort of try and group some topics that are coming to me, and then sort of reframe those questions for your response. The first thing, sir, is that people are asking what it is that young trial lawyers can do to, step into the system with that in terms of, say, situations like the Tamil Nadu incident that we just saw. That's one part of it, sir. And the other part of it is that assume that, we do sort of come up with some sort of police reform and investigative reform. As in, I'm skeptical from where I come, in terms of, so one of the things, for example, that has cropped up in case law recently is this duty of the police or the prosecution to act fairly in an investigation, right? And to produce documents that are exculpatory. So typically what we see is that in the charge sheet, the police tends to leave out documents that might be in the favor of the accused. And then when you're filing a discharge application under 227 or 239, the accused is sort of put at a disadvantage in showing that he can discharge himself. And now we have a recent decision of the Supreme Court which says that if the accused is able to show sterling evidence of an exculpatory nature, then given that we do have this deep-rooted distrust of the police, and we do have ample instance of them not acting fairly in an investigation, how do we go about democratizing the police, and how do we get them to trust? How do we get ourselves to trust them? That's.
Well, you are asking me a very fundamental question, which has perhaps been answered fairly to a certain extent in Prakash Singh. The combination, that's why I did not have time to go through that fully. That's why I said a non-uniform police, expert police force. You will find that the police force is burdened with a lot of responsibilities that they're not concentrating on crime investigation, right? And therefore, it's important that we have a branch of the police, call it by some other name. The name police has been so discredited in this country I think you find out a very good name for the police. And then say that they shall be in charge of investigation. They alone shall be in charge of investigation. Now, the other police may report to this police of a crime that is committed, but investigation must be entirely the responsibility of this, what shall I say, new police. You call it by any name, select a people's force, people's detective, something like that you call. And then, so that they should, and then it's important that we select the ideal persons to make this. The judiciary, generally it is accepted as a class different from the rest of the workforces in this country, right? Why? How did it happen? Because we groomed them to that level. We gave them independence. We always told them that it is your duty to account with reasons. Now, if a policeman is asked, one of the judges in Kerala, I could have said, now they oppose bail, they effect arrest, they oppose. You must say why I need to arrest him. For what reason do I need to arrest him? You have to account to yourself first that he has got to be arrested. And then there must be an order in the case sheet which will show why he is wanting the person to be arrested. I believe this accountability to reason is one factor which raises you to a higher level of existence. Well, we must develop a police force to that. In Kerala, I remember one of the judges, he said that the investigation is a very special, expert, specialist job, and therefore we ought to have universities where the police sciences will be taught. The Kerala government took it up on that, and then they had the plans of establishing a police university. It has not come so far, but what I mean to say is the core of detectives, whatever you call it, the new force. Don't call them police, because we have so much of distrust in the police now. Justifiably, please understand. Justifiably, And I was a lawyer. I had the police recorded a case diary. They wanted to record a case diary of mine. I told them certain things. Then he found that things were not going his way. So he said, "No, sir, we'll call you later." Later, when I was called to the witness, and I found my detailed case diary had been recorded. But what I did not say. So it's not. I'm only trying to assure you. It's not as though I do not know. I know the small window of 27. How much it has been misused by the police. I'm conscious of that. When I say trust the police, I'm not saying straight away start trusting them. No, that's why I said a non-uniform police force, which you can draw from the best of police officers already available, and then make sure that recruitment to that force is different criteria, pay them well, prevent abuse, prevent corruption. I've always thought, see, we say that all having an income of about 20 lakhs or whatever lakhs it is must go in for compulsory audit. Why don't we say that the officers of and above a certain level in the police force or in the judiciary or whichever force it is must also have that, so that they have an open book. They have their life is an open book. See, it's not as though we cannot do it. We don't want to do it. We are lacking the will, the political will, the civil society will to see it through. That is our problem, according to me. It's possible for this country to develop a police force which is trustworthy. They must inspire the trust of the people. And to get that, initially a lot of procedural insistence can be made. As I said, a statement recorded by you must reach your magistrate within 24 hours. It's something that you can easily insist and record. And then you can give it to him. See, and in one Mattu case, witnesses turn hostile. Everyone is so much worried. Hostility of witnesses. But that is what I'm seeing every day in court. A system where there is no sanctity for oath, people are at liberty to say whatever they want. We are not addressing ourselves to the core problems. That's the problem. I completely agree with. That's why I wanted to enter a caveat and say, please don't think that I'm saying that the police we can start trusting the police from tomorrow. The same police force from tomorrow. See, a lot of alterations will have to be made. So a lot of safeguards will have to be brought in before we start trusting. At least I say, start by trusting police officers of and above a certain rank. Give them the power to administer the Miranda caution and then record a statement. Insist that the statement will be recorded by such police officer in his own hand. Remember, the magistrates at a certain point of time, they were obliged to record it in their own hand. Instead that he records it in their own hand, so he is completely responsible for what is recorded. And come down heavily on people who deviate from the norms. It's possible. I don't think it's impossible. I always feel it's our lack of will to enforce that is troubling us.
Just to balance out this question, because I was anticipating this line of questioning given the circumstances that we have.
You are not very audible to me now. You are not very audible. Yeah.
So I think just to balance out this question, the previous question, I sort of anticipated that we are going to have questions on police reform given the circumstances that we have. And I had approached some young police officers at the IPS level prior to the lecture to sort of get their take on what's happening, especially on these sorts of issues. And their response was quite interesting. So they said that one, junior police officers are drawn from society. So we see a certain
not audible.
Can you hear me?
Not well. I can hear some.
One.
I can find a number of people saying you're not audible.
Is this better?
Yeah, it's better.
Yeah, sorry, I think my phone,
it's better. It's better.
Yeah. So, question, sir, is that I had approached some police officers for their view on this before I, came into this lecture, and what they said was quite interesting. So, and these are persons whom I know who are steeped in the human rights sort of framework as well. So they said two things. One, that if you expect your police to be very different from the society from which they are drawn, maybe that's too much of an expectation. And the police force is sort of reflective of the society itself. And if you have, say, corrupt people, you have corrupt society, corrupt police, and that sort of. So that's one thing that they said. And the other thing they said was, there are people from the legal system talk a lot about police reform, but what about judicial reform? They point to several cases which they say where states have set up scrutiny committees to sort of assess cases before they go to prosecution. But between the filing of the charge sheet and the actual trial, because there is judicial delay, there is the symptom of witnesses turning hostile, accused being bought off, that sort of thing. And they're saying that how are we accountable for that sort of thing? And I think perhaps we also need to, if we are honest about a profession, we must sort of give them that space to make these points about us. What are your thoughts on that, sir?
Well, corruption is a global phenomenon, and therefore everyone can justify themselves by the corruption. This can be done by the judicial officer. This can be done by the lawyers. I've often heard this. If judicial officers are corrupt, they're coming from the constituency of lawyers. If lawyers are corrupt, how do you expect? No, I would not agree. I would certainly say the finest of lawyers must come to the judiciary, and then with their screening must be possible. It must be possible. I'm not saying it is today. It must be possible. And, basically, as I say, how are you able to keep the judicial officers beyond a certain level of vicious influences? One is your accountability to reason. Two is, it's not only enough you have reasons, you must express them properly and with the full knowledge that somebody else is going to scrutinize it. Well, this is how judicial officers are also products of the polity. Same, or the bar. And therefore, if you ask me, how do they maintain a reasonably higher level? I don't know whether you would agree. At least from the state where I come from, I can definitely say corruption is not, that is monetary corruption, is not a major worry of our system of judicial system. I can certainly vouch for that. Not that it's a monolith that everyone is okay. I'm not saying that. As I use my words very carefully, it's not a major concern for our judiciary. It must be possible that the built-in safeguards, you are watering down one after the other, sir. The judges used to be recluse. They used to recluse. They never used to mix with society. Today you have legal aid. What is it? Legal Service Authority. You expect officers to go and make meetings. You'll do this. You do that. Things, the mantles which can ill suit a judicial officer, you are asking him to wear. Bakari Vasu said you must monitor the investigation and direct the investigators. It is absolutely inconsistent with your mantle which you wear of an unbiased adjudicator. See, one thing to say that the judicial officer must also be a participant in the search for truth. But entirely different to say that I must scrutinize the work of a police officer. I must sit in judgment, monitor and supervise the work of an investigator. See, in Emperor Mahmud, he said, until the charge sheet is filed, a court is to keep its hands off. And now, after the say 156.3 says conduct an investigation. Investigation means a proper investigation, and therefore the magistrate must also monitor and supervise the investigation. Well, I always feel the judicial system, the judicial officers are what they are because of built-in safeguards that we have given. And built-in safeguards are that you must give reasons. I think always that is the first reason, first plank on which we purify our officers. You must give reasons, and you must know that your reasons will be scrutinized by a superior person, superior court, and therefore all these arguments. I do not think it is impossible to construct a police. I'm again repeating the word police, an investigating force. I don't want to use the word police because it's so discredited. From the British times onwards, it has been an instrument of oppression. And therefore, the value system, which generally, I know there are outstanding police officers. As you said, I have also come across outstanding police officers. But that must be the rule and not the exception. Until we reach there, it's going to be difficult for us. And therefore, the argument that the corruption is global, we also come from the same society, are not answers which I would purchase. I would not accept that, certainly.
I think I sort of agree with you there. So I put it out there because I wanted a sense of balance to be there in our questioning. One of the things that you spoke about is this, this situation of A hitting B and A being asked, what did you do, but B not being asked, that sort of. But, in fact, 2 or 3 people have asked this about the role of the 313 statement, because that is where B is asked to put his version of the case. And one question that came about the 313 statement is, given that is his line of defense, other than the suggestions that are put to witnesses, is it crucial that trial court judges and appellate court criminal judges sort of deal threadbare with the defense taken in 313 statements? And, what is the role of the 313 statement in this entire process?
Well, very, very interesting questions of great importance you have asked me. The 313 that I have in mind, I told you, so because I didn't have the time to expatiate on that. If you read 313, it will say that a judge may, at any stage of the proceedings, put any questions to him. That is point number 1. See, like, for example, if PW1 comes and says, I saw B driving the vehicle, I think even under the present law, it's possible for the court to stop proceedings there and put a question to him. He says that you were driving the vehicle at that time. What have you got to say about this? He can. Even in today's law, you can. I've not seen anyone doing that. Please read 313. I don't have the book now. Please read 313. 313 says the court may at any stage of the proceedings elicit an answer from him on this. What the 313 that we are talking about is an opportunity given to the accused at the end of the trial to comment on all incriminating circumstances which have been brought up against him. The 313 that I am talking about, I refer to it, is the earlier part 313. Now, supposing the signed statements of witness are made admissible, supposing the witness are furnished copies of those statements come to court within 24 hours. Supposing the court issues notices to them saying that please have produced this statement as your statement. What have you got to say? You can mention, you can file your response. And then at the trial, the prosecution produces all these statements. What harm is there on those signed statements, the court questioning the accused? A says, B says, C says, you were there at the scene of the crime. What have you got to say about this? Only that. He can, of course, say the great right to silence. He can say, I do not want to reply to this question. But even under the present 313, appropriate inferences can be drawn, though they cannot be the foundation for conviction. Right? And therefore, if PW1 comes and gives evidence, supported by a signed statement, supporting by earlier FIR. He comes and gives a statement. The court must have the ability, the moving space, the elbow room to ask a question to the accused. This is what is alleged. What have you got to say about it? Evidence would come only later. On the signed statements, the questioning, I'll have to explain long. I don't want anyone to go away with ad hoc impressions on what I say. I have an altogether different plan for this, and it's my conviction or my experience that it is possible. So that, see, look at today's situation, sir. What is happening today? The prosecutor has to worry about necessary evidence, unnecessary evidence. He doesn't know. He doesn't know. The accused is just standing there like a villain, not opening his mouth, not pleading, not pleading, refusing to plead. At the end of the trial, at the argument stage, he'll come out with versions. So that the prosecutor is to fret and fume and reduce a lot of unnecessary evidence which may be irrelevant. Well, this question worries me. Which rule of natural justice, which rule of refined fairness to the accused is offended if you even earlier ask him that this is the allegation, this is the factual allegation, what have you got to say about that? Are heavens going to fall down? Are people going to, is our sense of justice offended by giving him an opportunity to explain? I thought natural justice was giving him an opportunity. And if you give him an opportunity and say PW1 says, he can tell me, sir, PW1 is unbelievable. He has a motive against me. He is not speaking the truth. Two, also he can say that. But then at the end of the day, if I'm satisfied that PW 1 and 2 are there, necessary inferences will be drawn against him. So that my point is, the right to silence cannot deteriorate into an arrogant refusal to cooperate with the truth discovery process and leaving everything for the prosecution to do it. We don't have the time, sir. We don't have the time to do that. We don't have the time for the criminal court to worry about undisputed and disputed facts, not knowing what is disputed and what is not disputed. Well, see, in one session when I say this, I'm sure many of my friends must be finding it there. This man has gone off his head, all the 50 years of experience is of no use. He does not know the police. He does not know how the system is functioning. This could be the response. But, I want, if we could go in for a more detailed discussion of the individuals, representative individuals, I think it must be possible to convince them that this, I keep repeating this. What is it that I've been doing during the last 50 years? Have I been playing a drama where rules, the technical rules are more important than the discovery of truth? Well, that is what worries me. What worries me more is the want of a thinking to improve the system. That is what is really worrying.
Thank you, sir. We are also out of time. There are so many more questions, but I'm unfortunately not able to ask anymore, and I do need to wind up now. Thank you so much for your time, sir, and also for this wonderful lecture. I'm sure we've all learned a huge deal. And like I said, from the questions I'm getting, you've caused many people to rethink their assumptions. For that, we are all grateful.
Gautam, as I said, I would like to provoke people to think. You see, I want the disturbance to be created. Am I a meaningless cog in the whole wheel, performing functions which are irrelevant, which are just technical, or do I have a role in the truth discovery? The disturbance must arise from that, and I want people to think. That's my purpose. And if questions reveal that, I'm very
I think it's very fair to say that you right. So I'm certain we are all thinking very, very much about what you've said, sir. As in, it truly was very enlightening and provocative. Thank you so much for your time. Again, thank you so much to the LibLaw team for organizing this. I had sort of written a short piece on the need for mentorship in the profession for LibLaw a few weeks ago, and I received a stream of responses to that saying that, listen, you seem to have hit on a nerve here. We all want mentorship. And I do hope this can be institutionalized. As in, lawyers in the Supreme Court know of the Friday group, and we've all benefited from it. And I understand because of its YouTube channel, many people have benefited from it. I hope that is true for the LibLaw series of lectures that we have inaugurated today. And I hope there will be many more such lectures. And we will have you, sir, for many such lectures also. thank you so much for your time. Thank you everyone for attending. Is there anything else I need to do right now from the library team, or can I just end this lecture here?
You can end.
I can end? Thank you.
I think we had a wonderful session. Thank you, sir. Thank you, sir. And thank you, Gautam, for making this huge
Thank you so
big
much.
for the webinar today. Thank you a lot.
Thank you.
Thanks.
Thank you. Thank you.